So, a little known fact of Scribelite lore is that the first person who ever followed me on Twitter, and to this day I do not quite understand why, but I'm eternally grateful, was Elizabeth Gore, the CEO of a company called Hello Alice. Like I say, I don't know why she followed me, but she was my first, so I have a certain amount of appreciation for her taking a shine to me, as it were, at the time, for whatever reason. And so it caught my attention yesterday when I saw a post from her on Twitter, or X, regarding her own company and some struggles that she's having regarding DEI. And so I couldn't help but wonder what's going on and what the story is, given my predilections for looking at DEI stories over the years. So let's take a look. Job cuts, fleeing investors. How anti-DEI lawsuits take a toll on targets. U.S. businesses sued over their diversity programs are making tough decisions about if and how to fight the threats. And as I've said numerous times previously, I'm not surprised. DEI has always been a landmine just waiting to go off. And this is from Bloomberg on February 29th, 2024. Elizabeth Gore is fighting for survival. Just 6 months ago, the founder of financial technology startup Hello Alice was getting ready to close an investment round to grow its business, offering grants and networking opportunities to entrepreneurs from underrepresented groups. Then it got sued. The August lawsuit, filed by conservative activist group America First Legal, took issue with a grant program that Hello Alice co-runs for Black-owned small businesses. Only offering the money to Black entrepreneurs was, the suit claimed, discriminatory. And it inherently is, because you're valuing someone on the basis of their skin color first and foremost, which, last I knew, was something we're supposed to be trying to merge out of our society, but I digress. The impact of the suit was immediate. Houston-based Hello Alice, which also offers credit and loans, shared the news of the case with potential investors as part of its due diligence process, and 2/3 of the capital was pulled out. It spent 6 figures on fees for 3 law firms so far, and is budgeting, multiple 7 figures if the case continues. Quote, "It was surprising how quickly we lost some key investors," Gore said in an interview. "We just watch money go straight out the door." And I've been saying this in one way, shape, or form for years. DEI is a losing proposition. It is inherently antithetical to established civil rights law, and it was only a matter of time. It took way too long, in my opinion. I mean, I've been covering this kind of stuff for 7+ years now, but the chickens, as they were, coming home to roost. And the affirmative action decision of last June really set things in motion, I think. Again, many years too late, but I guess better late than never. Gore, 46, is on the front lines of a litigation war over diversity in corporate America. It's not about diversity. It's about systemic discrimination. Called DEI, but they're doing their best to try to make themselves still seem like they're doing something virtuous, I suppose. Conservative activists, emboldened by the U.S. Supreme Court doing away with affirmative action in college admissions, have now set their sights on professional diversity programs. That's because the decision for affirmative action in colleges, while it affected Title VI, or involved violations of Title VI and the 14th Amendment, the structures of Title VI are practically mirrored by Title VII, and Title VII covers private businesses and employers, whereas Title VI covers, generally speaking, organizations that take federal funding. But the restrictions are the same. You cannot discriminate in opportunities on the basis of race, gender, ethnicity, country of origin, religion, and so on. If you cannot argue diversity to justify racial discrimination in colleges, race has the same footing in both Title VI and Title VII as violations of the law for doing so. So a diversity argument in the corporate world definitely carries no weight now that it's been dismissed as giving any coverage in the collegiate world. But again, I I divert myself. Right-wing legal firm AFL, created by Donald Trump's former advisor Stephen Miller in 2021, has lodged complaints with the U.S. Equal Employment Opportunity Commission against more than 20 companies, including American Airlines Group Incorporated and McDonald's Corporation, as well as the National Football League, and filed at least 6 other DEI-related suits, mainly arguing that efforts to hire and promote more women and people of color amount to discrimination against others. It inherently is discrimination against others. If you're putting race and or gender up front as a consideration for employment opportunities or promotion opportunities, you're breaking the law. Fighting in the same corner is Edward Blum, the activist behind the group that first sued Harvard University over its affirmative action policies. His American Alliance for Equal Rights has filed a flurry of suits against law firms and small startups, including the Fearless Fund, an Atlanta-based venture capital firm that invests in businesses founded by women of color. In September, judges temporarily halted its $20,000 grant program, writing that it was, quote, racially exclusionary, which it inherently is. I love how these things are framed as though they were maybe question marks or allegations. It's right on the label. They make no bones about it. Around the same time, the Fearless Fund was supposed to close an eight-figure fundraising. Quote, it got dismantled just due to the lawsuit, unquote, Chief Executive Officer Arian Simone said in an interview. A major investor in its first fund, J.P. Morgan Chase & Company, said it wouldn't invest in the new fund, a Fearless Fund spokesperson said, describing the decision as a catalyst for others to walk away. Almost 6 months later, the firm is still trying to make up commitments. Again, this is the funny thing. It's not as though the structures or the mechanisms of DEI have changed suddenly in the last 6 months. It's always been like this. It's just that only now people are starting to say, yeah, people are paying attention. We can't get away with this anymore. You know, Puxatawny Phil looked up and finally saw his shadow. That's the situation. A representative for J.P. Morgan didn't comment on the Fearless Fund specifically, but said in a statement that it remains committed to supporting entrepreneurship among underserved communities. That's interesting language to use there. That's very diplomatic descriptions. I think we're going to have to chase back to that pretty quick to avoid any more lawsuits. Blum said that it was not surprising, unquote, that investors were pulling money. Quote, no investor wants to participate in a business endeavor that the courts are highly likely to find discriminatory and illegal, unquote, he said in a statement. Well, unless you've been operating under the DEI rubric for the last 7 or 8 years. Both sides are still waiting on the final word. The Fearless Fund is challenging the judge's decision, and no other case has made it through the court system to a verdict. But the threat of legal action has been enough to send a chill across diversity, equity, and inclusion efforts. Even at companies that haven't been targeted, lawyers say they're recommending broader parameters for programs that are less likely to attract scrutiny. Meanwhile, DEI departments are shedding staff, and the number of U.S. DEI roles on the job listing site Indeed.com is 16% lower than last year. Again, nothing about the DEI infrastructure has changed since I've been looking at it over 7 years. Only now, with the fear of mass class action civil rights lawsuits, are things changing. And only because the Supreme Court pretty much drew a line and said, diversity is not an excuse for discrimination. All these companies that haven't even been targeted yet, they are wise to back away. They are wise to try to hide for as long as it takes for any statute of limitations to run out. Because you can't tell. If a company's been running a DEI program for 5 years, and in those 5 years they have made countless hiring and promotion decisions based on DEI rules, well, that means that everybody that they didn't choose now has conceivably a claim against that company for civil rights violations. And how many people could that be? How much money does that constitute, do you think? Conceivably. Or how much of a headache is it going to cause, even if the company comes out on top eventually, the legal bills and the bad PR in the process? Yeah, DEI has always been poison. It just took a really long time to kick in. Some businesses are taking immediate action instead of duking it out in court. In recent months, law firms Morrison & Foerster, Perkins Coie, and Winston & Strawn have each eliminated diversity requirements for fellowships, a common tool for recruiting from underrepresented groups. All were sued by AAER, which dropped its cases after the changes were made. Pharmaceutical giant Pfizer Incorporated removed race-related requirements from a similar fellowship after an advocacy group for medical professionals and students challenged the program. A spokesperson for Perkins Coie declined to comment. Morrison & Foerster, Winston & Strawn, and Pfizer didn't respond to requests for comments. Yeah, they're trying to get as far away from this as they can. The writing is on the proverbial wall. A lawsuit filed by AAER against Hidden Star, an Austin-based nonprofit, wrapped up in 3 weeks after the company agreed to change language on its website for a program aimed at women and minority entrepreneurs. Hidden Star always allowed anyone to apply for its grants, according to founder Mike D.E.I, but some of its messaging wasn't clear. Sure. It has since taken down a specification that applicants must be a, quote, confirmable ethnic minority, unquote, and removed a requirement to disclose race on the application. Let's back up a little bit. Hidden Star has always allowed anyone to apply for grants, according to founder Mike D.E.I, but some of its messaging wasn't clear. And the quotation is confirmable ethnic minority. Mike D.E.I, I think you might be just fibbing a bit. Just a bit. At issue in both the Hello Alice and Fearless Fund cases is Section 1981 of the Civil Rights Act of 1866, put in place after the Civil War to protect formerly enslaved people from discrimination when entering into and enforcing contracts. The conservative groups argue that programs targeting underrepresented groups discriminate against anyone that falls outside of those categories. Companies like Hello Alice counter that their grants aren't contracts and that Section 1981 shouldn't be read that way anyway. But fighting that battle in court is costly. Hello Alice has been funding the expenses itself, though Gore said it won't rule out asking for outside financial support in the future. At the end of last year, quote, a chunk of the team, unquote, was laid off, said Gore, while declining to give specific numbers. The company said it's nearing the close of the Series C round that got delayed last year. It was oversubscribed before the lawsuit hit, and some existing investors increased their investments, but the money is coming months later than planned. This month, the EEOC, which is responsible for enforcing federal laws that make it illegal to discriminate in the workplace, filed a brief in support of Hello Alice. At the Fearless Fund, too, cuts have been made. Since the suit was filed, staff at the company and its sister nonprofit foundation have been cut to 9 people from 16, a spokesperson said via email. Quote, we have definitely seen the hardships of this lawsuit, said CEO Simone. Despite the risks, Hello Alice, named for the fantastical story of the girl who fell down the rabbit hole, is prepared to fight to the Supreme Court, where federal legal precedent could be set if it has to. Quote, if Hello Alice loses this case, it could threaten billions of dollars that flow into small businesses every year, unquote, said Neil Katyal, a partner at law firm Hogan Lovells, who is representing Hello Alice. Yes, that flow into small businesses every year, predicated on the race and or gender of the people running those businesses. See, here's the thing. Either it is morally and ethically correct to limit or allow opportunities for people on the basis of their race and or gender and or religion and or country of origin and or ethnicity and so on, or it's not. That's the long and the short. Okay. Either we as a society are promoting the idea of individual merit and individual character, regardless of aesthetic appearance, or we're not. And grant programs and job opportunities and other things similar that first have a filter of, are you a particular skin color? Are you a particular gender? Are you a particular orientation? And so on. They are inherently discriminatory. They are inherently, if not violating Title VII and Title VI, they are violating the spirit of why those laws were created in the first place. So, while I very much appreciate Elizabeth Gore being my first follower on Twitter, or X, I have to say that Hello Alice, participating in grant programs as other entities have, that first have a filter, a racial test, a gender test, doesn't pass muster with me, and they need to be challenged in court. Now, ultimately, the legality of those programs will be decided either by the Supreme Court or other courts and so on. And that's outside of my hands. But in my opinion, they promote an idea that we are supposed to be moving away from in this country. It's antithetical to it. It is inherently antithetical to the idea that you have an opportunity, regardless of who you are or what you look like, to have success in this world and in this country in particular. But anyway, let me know what your thoughts are in the comments below. Be sure to follow me on Twitter or X at scribe_light. And you too can join Elizabeth Gore in tracking my online career. I don't know what you want to call it. Look out for TED Excellence on Thursdays at 6 p.m. Pacific, 9 p.m. Eastern, where I'll take a look at another off-brand TED Talk for education and entertainment. Everyone, I hope you have a good day. Hope you are all safe and well. And if you're not well, please get well soon. And I'll see you on the next one. Take care. Bye-bye.